got your back every day. Who you gonna call? NTA, who'll help you succeed along the way. NTA.
There we go. Okay. Wayne, why don't you kick us off?
Welcome, everyone. My name is Wayne Schooling, and I am President and CEO of North American Transportation Association. I started driving in the mid-'60s with Pacific Intermountain Express, which was just about half a century ago, to tell you the truth. But today we are pleased to welcome Miles Cavalier to the webinar. He is a regular contributor and has a column on our website. Miles, let me give you some background on Miles. He was admitted to the New York Bar in 1972 and the California State Bar in 1977. He was actually employed by the Bureau of Enforcement of the Interstate Commerce Commission, the old ICC, as a trial attorney and assistant regional counsel from 72 to 77 in Washington, D.C., Chicago, and finally in Los Angeles, where in 1977, he went into private practice and became a sole practitioner in '85. Miles specializes in transportation law and litigation. He regularly practices in federal and state trial and appellate courts, litigating virtually any matter which arises in the transportation business. He routinely handles cargo claims and freight charge collections. He has also litigated trade secret protection, insurance, bad faith claims, employment law, and various commercial disputes. In addition to litigation, Miles frequently counsels shippers, trucking firms, and intermediaries, such as brokers and forwarders, regarding Federal Motor Carrier Safety Administration and Highway Patrol requirements, carrier and warehouse liens under the UCC and federal law, liability for payment freight charges, and cargo claims. So if you've read this morning's paper of the Long Beach Press Telegram, they call AB5 the most nefarious law to come out of the recent legislative session. So with that, I am going to turn it over to Miles, and he can take over.
Well, thank you, Wayne, and good morning to all you folks who are participating in today's webinar. I'm pleased to be here and to offer my views and assistance in this very telling time for what is going to be a substantial change in the transportation industry, certainly in California. You see the first slide addresses AB5 and what it does by establishing a new statutory test for employees. I want to go back a little bit and explain why we are here. The issue of classification of workers, and in our industry, particularly drivers, has been a complicated issue for many years. Historically, the interstate trucking industry has relied on independent contractors to perform much of the line haul transportation activities of interstate carriers. And the issue of whether they were being properly classified as employees or independent contractors really did not arise significantly until probably within the last 5 or 10 years, and more specifically in the ports in California, in Long Beach, Los Angeles, and Oakland. And because, frankly, of the inordinate cost of workers' compensation, many trucking firms classified, oftentimes knowingly improperly, as independent contractors so that they did not have to purchase workers' compensation coverage. in addition to treating or misclassifying drivers as independent contractors in order to avoid workers' compensation, other costs ordinarily incurred by employers for withholding, Social Security, and other payroll taxes, those are not paid as well. So there have been hundreds of complaints which local drivers filed with the Industrial Welfare Commission's Labor Standards Enforcement Division, complaining about the compensation that they were receiving and that they had been improperly classified as independent contractors when they should have been classified as employees. The Labor Standards Enforcement folks found in, I think, if not 100%, then 99.99% of the cases that the complainants were employees and had been misclassified as independent contractors. And the law which the labor standards folks applied was what you may now be heard to refer to as the Borello, B-O-R-E-L-L-E-L-L-O case. That was a case decided by the California Supreme Court in 1989, having to do with agricultural laborers and whether they were independent contractors or employees. And it established a number of criteria which a court was to look at in order to classify a worker as an employee or an independent contractor. And the Borello test essentially addressed the manner and means of completing the assignments which a worker was given in order to determine whether or not that worker was an independent contractor. The Labor Standards Enforcement Division used Borello, and in all of the cases, or virtually all of the cases, found that given its criteria, the truck drivers who were complaining were employees and not independent contractors. That eventually led to the case in the California Supreme Court, the Pack Anchor case, where one of the port carriers, Pack Anchor, was challenging the state's suit, asserting that it was responsible for the payment of payroll taxes. And Pack Anchor argued, no, all of these drivers are independent contractors. And the California Supreme Court in the Pack Anchor case used the Borello test to find that none of the Pack Anchor drivers were independent contractors, they were employees, and further, that what we now refer to as the F4A, the statute in the Interstate Commerce Commission Termination Act, which preempts federal law where a state would seek to regulate a carrier's prices, routes, or services. That preemptive statute was found not to apply in the Pack Anchor case because in Pack Anchor, they were only determining whether or not the drivers were or weren't independent contractors. The Dynamex case, which led to the AB5, decided that rather than the court examining all of the various 10, 11, or 12 factors in the Borello analysis, that it adopted what it called the ABC test. So this is a shortcut for courts to use in determining whether a worker is an independent contractor or an employee. So let's go to the next slide, please. So item 1 really just sets up the next item. Go to the next slide, please. So the ABC test, first we have A, which really doesn't concern us. let's go to the next slide, please. B, this is the one. So this aspect, this part of the ABC test, if the person performs work that is outside the usual course of the hiring entity's business. So in order to be an independent contractor, the worker would have to perform work that is outside the usual course of the hiring entity's business. So let's flip that around. If the person performs work that is inside the usual course of the hiring entity's business, then that worker is automatically an employee. So trucking is a perfect example. You take somebody who is now classified as an independent contractor, they own their own truck, they lease it to the carrier. The carrier, of course, is in the trucking business. The driver is in the trucking business. It's automatic, folks. That driver is an employee. So let's go on to the next slide. The A and C portions of this test, nobody's arguing about. And frankly, the A and C portions of this test were part of the Borello analysis anyway. So what the trucking industry is focusing on is the B test, where it essentially prohibits any driver from being classified as an independent contractor and must be classified as an employee. Let's go on to the next slide, please. All this says is once you're an employee, then all of the provisions of California law are going to apply. So everybody who is participating in this webinar has employees who are not truck drivers. So all of the benefits that those employees get now have to be given to truck drivers who were independent contractors. So not only unemployment insurance, but eventually as of July 1, workers' compensation must be paid, and all of the benefits of the labor code applicable to employees have to be provided to truck drivers. One caveat, if you will, and that's meal and rest breaks. The Federal Motor Carrier Safety Administration administrator has issued an opinion stating that for carriers subject to the hours of service regulations and who maintain logs are exempt from the California meal and rest break requirements, but are, of course, are subject to the requirements in 49 CFR 395 pertaining to hours of service. That decision has been challenged and is pending in the Ninth Circuit Court of Appeals for decision. And my guess is that the Ninth Circuit Court of Appeals is going to invalidate the FMCSA decision and require that truck drivers in California who are nonetheless subject to hours of service will also be subject to California meal and rest break. For now, that's not the case. All right, let's move on to the next slide, please. So what are you to do? Years ago, I had a meeting with a client and they had just engaged under the new rules, the Clean Air Act rules in the ports, and they had bought a bunch of trucks, clean air trucks. And what are we going to do with them? We've sold them to our drivers and we've leased them back, and the drivers are not happy because they're not getting the credits that we thought we would be able to provide to them in order to pay for their tractors. So the drivers were unhappy. And I said to this client, do you cover these folks with workers' compensation? The answer was, no, we don't. They're independent contractors. Well, do these drivers have occupational and accident insurance? Well, no, we don't know what that is. So at that time, and this is long before Dynamex and long before AB5, my advice to them was, well, if you treat your drivers as employees, you will never have a problem. And that is my advice to you now. If you treat all these independent contractors as employees, you will never have a problem. The problem with doing that, I think everybody who's listening to this webinar will say, but if I do that and I pay workers' compensation and provide all of those employee benefits, my costs go up 30%. And the rates I'm getting now certainly don't cover that. I can't stay in business. So if that is your thinking, then you have a big problem. Excuse me. So what are you to do? If you cannot change your business model and treat all of these 1099 drivers as employees and absorb that cost, or go to your customers, I think everybody in the industry is going to have to go to their customers and say, look, AB5, we've got to bump your rates up. If everybody is going to do that, and please don't talk amongst yourselves about doing that, because that becomes an antitrust violation. But if everybody independently comes to the same conclusion, then all the rates are going to go up. They have to go up. Either that, or there will be a major consolidation in the industry, and only those carriers that can afford to pay employee benefits will survive, and the small guys will be driven out of business. So that's one of the options. There's another option, and that is do nothing and wait for a legislative change in the next session of the California legislature, or wait for court decisions on cases that are going to be or have been filed challenging AB5 based on the F4A preemption. Excuse me. The problem with that approach, if the challenges are unsuccessful, if there is no legislative change made, and there are differences of opinion whether or not the California legislature will entertain the trucking industry's requests for an exemption. If those political issues are not resolved in favor of independent contractors, or providing some exemption or carve out for trucking, then those carriers who have not changed their business model and have hoped for a change and continue to treat their independent contractor drivers the same way they have been could very well be subject to essentially retroactive treatment and the imposition of all of the taxes and other compensation to drivers that would have been required or would have been paid had the carrier changed its business model. So there is a big risk in doing nothing. Now there's another possible alternative. And that's the last item here on the alternatives. Change your business model to the broker carrier model. Now, what does that mean? It means that all of your independent contractors become their own carriers, and that you, the trucking company, become a truck broker. And there is a difference between a broker and a motor carrier. And essentially, the difference is that a broker arranges for transportation, the carrier provides that transportation. whether or not your company can make this change and whether or not its independent contractors are willing to go through the steps is highly questionable. Let's go to the next slide, please. So here are the basic things that would have to be done. Your independent contractor drivers who own or lease their own trucks, they would have to or should incorporate, form a limited liability company or a limited liability partnership. Now, that's not a requirement, but if you're going to be in your own business, as I'm suggesting that an independent contractor who wants to become a motor carrier, some of them already are and know exactly what I'm talking about, then those folks should have the type of business organization that businesses use to conduct their activities. Corporation, limited liability company, liability partnerships. Then, of course, the contractor would have to get their own FMCSA registration and California MCP. The big problem is going to be insurance. We go to the next slide, please. Many carriers carry their own auto liability insurance and cover all of the trucks that operate under their operating authority with that auto liability and cargo insurance, and then deduct from the contractor's compensation prorata portions of those insurance expenses. The problem with continuing to do that, while it is certainly good for the contractor, or what would now be, well, would remain a contractor, that contractor could not use that insurance and transport cargo for other carriers. One of the criteria for determining whether in fact a carrier is independent of the company to whom it leases its equipment has been whether the carrier can reject loads. In this model, the independent contractor has become its own carrier. So that independent contractor can get loads from any broker or other carrier. And incidentally, carriers who broker loads must also have an FMCSA broker license for interstate broker activities. As a note, California no longer requires intrastate truck brokerage to be licensed. So in this business model, if the independent contractor is willing to become its own carrier and incorporates, they of course have to fulfill all the requirements for being a motor carrier. And of course you have automobile liability insurance. That's one of them. But it gets a little more complicated when you talk about the folks who operate in the ports, because you need a concession agreement, and you also have to have the intermodal interchange equipment agreements with the chassis suppliers, and whether those agreements will be undertaken with the new carriers that I'm talking about here, that becomes a big issue, a big question mark. So the broker carrier business model may not work for port operators. I suspect it will not. Let's go on to the next slide. So I guess we get back to, what do I do? And the answer is you can comply or you can take your chances. And my recommendation is that if you can make all of your drivers, employees treat them as employees as of July 1, if not earlier, cover them all with workers' compensation. And if you can bear those costs, you will be safe. If not, you're going to take your chances. There's a couple of minutes left. I don't think that we can take questions, but perhaps Wayne, you have some ideas, anything that you want me to address.
My question would be, if they do comply and change over to a W-2 employees, and then 3 months down the road, some court decision throws all of this to the wayside, what's the chances of converting back to 1099?
Well, this is a dilemma. If you change your business model now or over the next couple of months, the likelihood of the company going back to the independent contractor model, I think, is slim. It could, but before you would do that, you'd want to have finality. These court cases are going to take years, and frankly, whether or not there's a F4A preemption of AB5 is going to go to the United States Supreme Court. There are decisions in at least one other Federal Circuit Court of Appeals, the First Circuit and the mass delivery cases, which says prong B, the B test, is inconsistent with the F4A, and F4A preempts it. Whether or not we're going to get that in other courts of appeal, nobody knows. And then ultimately, if there are different decisions in different courts of appeal, the Supreme Court will rectify that. That takes time. So that's the problem with this. If you comply and you go to an employee model, the going back to the independent contractor model would be not likely. It would be difficult. Now, having said that, it could be that at the time that there is a final decision on this issue, all of the operations at that time could, not necessarily with its existing employees, but with new trucks, with new truck drivers, make them independent contractors.
Well,
I think I've answered the question. I'm not sure.
One thing that I do know from personal experience is that way back when FedEx Ground was having their difficulties, a bunch of drivers from the Torrance facility came over here, and through our association with our in-house CPAs, we set the group up as an LLC, but taxed as an S corporation, so that each person only paid taxes on what they made, and there was nobody took the big hit. And this is going on quite well at FedEx Ground. So think that not going to the broker carrier model is probably the most, in my opinion, the most cost effective in the long run, to tell you the truth.
Wayne, it's at least theoretically a model that I think will work. There may be some question about it if the authorities think, well, this is just a disguise for the real relationship, and they're going to challenge that. There's no way of knowing how that ultimately will come out. That to me is the only way around AB5, unless AB5 is found to be preempted.
Yeah. Well, we've taken it one step more about the advertising feature that they may question. So on our website, in the top right hand, we have where it says heading is directories, we have a motor carrier shipper directory. And for the members of NTA, we are going to offer a special rate for advertising at $60 for the year, so they can advertise their services throughout the United States. And with our connection with Constant Contact, our IT person will actually create their own web page, so that they can say that, if you wanted to see more of what I do, just go to, wayneschooling.com or whatever, the applicable name may be. There is kind of a catch to that, in that they do have to set up with Constant Contact a $20 a month advertising fee to go with that web page. But that would at least take care of any advertising things. I don't think we can get too much more. I really don't have any other ideas at the moment.
Wayne, I just saw a little note at the bottom of my screen from Katie. I don't know if you saw that, and I'm not entirely sure what Katie was asking. I saw that the thrust of it was double brokering.
That's against the law.
I'm sorry?
To me, that's against the law, isn't it?
Well, typically the agreements between a broker and a carrier will prohibit double brokering. But it's not against any statute. But double brokering really doesn't solve the problem, because sooner or later somebody has to be the carrier, and whoever that carrier is uses drivers, and those drivers, if they're California-based drivers, have to be employees.
Okay, I'm just seeing one from Daisy, and I forgot, I think Denise was also in there too. Oh, wow, there's so many coming in, I can hardly keep up with them. Yeah, Jason, that only applies to California companies.
The answer to that question is, for our purposes, yes. The analysis gets way more complicated when you talk about out-of-state carriers using in-state drivers, how much business they do in California, whether an out-of-state carrier with out-of-state drivers who does a lot of business in California would be subject to that. There are a lot of open questions about this. So the concept in the law is called extraterritoriality. Can a state apply its laws beyond its geographical limits? And there's a lot of law on that. So,
and there's some carb law on that too. If the trucks from Missouri come in, they have to have their reefers have to be up to California.
But the basis for CARB is that, hey, if you're coming into our state, we have a jurisdiction to tell you about what requirements your trucks have to meet for clean air standards. This is, does California labor law apply to workers who are not residents of California? So it's a little different analysis. Yeah. Are there any other questions, Wayne, that we can answer at this point, or are they just going to have to email you?
I didn't catch the name, it was so quick, but they asked about the two-check system. My sources have gone back to the Scopolitis group, and they've kind of advised that that's not enough. How do I want to say this? Not enough of an arm's length distance that they advise against the two-check system.
What do you mean by the two-check system?
From what I understand, you pay the driver the minimum wage for that to keep your work comp, pricing down, and then you have another agreement where you lease back his equipment and you make up the difference. And so, in other words, at the end of the year, he gets a W-2 and a 1099.
Well,
that's the way I understand.
The issue here is not the form of compensation. The issue here is the application of the California Labor Code to workers. So you can determine the method of compensation, combination of W-2 and and a 1099 for expenses. There's nothing in AB5 which addresses that.
Yeah.
So the question is that worker an employee entitled to the benefits under the California Labor Code? and workers' compensation? And the answer is you can use 30 checks. The answer is you're still subject to the California Labor Code
Yeah,
for a
but
California company with California drivers.
yeah, you just make him an employee, but you only pay him, the minimum wage to keep.
You can pay a minimum wage, absolutely.
Yeah. And
But you
somebody
don't
asked
have to
about,
reimburse them for expenses.
yeah, somebody asked about does occupational accident take the place of workers' comp? No, it does not.
No, it doesn't.
It's just it's only can be issued to a 1099 person.
And Wayne, I'm not sure which carrier you use. I know that at least one insurance carrier did have essentially their OCAC, which was master billed through the carrier, did have a workers' comp coverage in the event that the driver filed a workers' comp claim in addition to collecting benefits as an independent contractor under the OCAC policy. But I've also seen a policy that if the driver files a workers' comp claim, then the OCAC is voided and any money paid under the OCAC has to be paid back to the insurance carrier. But the long and short of the question is no, OCAC is not a substitute for workers' compensation. It's typically carried by independent contractors because the cost is way, way less than workers' comp and affordable, but it doesn't carry the same or doesn't have all of the same benefits of workers' comp, so that a driver can file a workers' comp claim even if he or she has OCAC.
Yeah.
Under the AB5, they're all employees, so they got to be workers. They got to be covered by workers' comp, not OCAC.
Yeah.
And you will not be able to get an OCAC policy in California.
Yeah. Kevin just bipped in there that what if his employees don't, or what if his drivers don't want to be employees? It's not really a choice, because but I think what people have to understand, and correct me if I'm wrong, but the company has to prove that if they don't meet this ABC criteria, they're automatically employees. So the driver doesn't have a choice in the matter, to tell you the truth.
Okay, I think Wayne, you're correct. And this really comes down to, for many, and I had this discussion just this past Saturday with a bunch of drivers for another client. And this is, in my view, government overreach.
Definitely.
Where the government is telling you, you don't have a choice. So you, the independent contractor truck driver who has been happy with that, no problems, no misclassification, you would be an independent contractor under the Borello test, and you don't want to change. Everything is fine. You're being compensated properly, and so on and so forth. This is the government telling you, sorry, you are now an employee. Now, I have suggested that people who don't want to become employees write to the legislative representative in their district and tell them, I don't want to be an employee. I'm happy as a clam being an independent contractor. I've never been mistreated. Why are you imposing this on me? This is a political question.
Yeah. In fact, actually, a couple of years ago, the Wall Street Journal did an article on independent contractors and found that they actually make more money than a regular employee driver. So,
let me interject here. The misclassification problem arose where carriers did not determine whether the driver wanted to be an independent contractor. And there is a difference.
Yeah, they took it.
Clients, an independent contractor is a worker who wants to hustle and make money.
Yeah, they are
not the kind of worker who says, I'm going to come in and do my 8 hours and go home and have dinner. And those are the employee types. And the hustlers are the independent contractor types. You
Granted.
cannot force the worker type to become an independent contractor, and shouldn't. So a lot of the misclassification took the guys who wanted to really just be employees and forced them into the independent contractor model, and they really didn't want that, and they really weren't treated fairly.
Yeah.
I saw something else from Katie. Can an out-of-state carrier use California independent owner-operators? You run a risk. I would say the answer is yes, but here's the thing. The owner-operator is the one, or the driver, let's put it that way, is the one who would institute legal proceedings, whether before the Labor Standards Enforcement or a lawsuit, saying I've been misclassified and I'm owed money. If you have drivers who want to be independent contractors, they're not going to run to court or to the Labor Commission and saying I'm being mistreated. So in that respect, using owner-operators who are domiciled in California, leasing their equipment to an out-of-state carrier, and now the question becomes to how much business does that out-of-state carrier do in California? Should it be subject to California law? We don't know the answers to that type of question yet.
Well, for those motor carriers who want to go the broker, carrier model, we have put together a package with our service provider CPAs next door. And we're going to try and do this within a 72-hour window, is whether they want a C corporation, an S, or an LLC, put all of that together for a flat fee, and including the payment to the state, so that they can do that. Now, the bad thing about it is if you incorporate too early, you're going to get hit with the California minimum California tax of, I think it's $800. So what we're doing is collecting names and getting everything in order, so that on December 15th, we do the filing for them. And it's going to be a busy 2 weeks, I have a hunch. But at least they don't pay the, that year's tax, and they get the first year for free. But that's,
Wayne, do you also have, can you also help people get their FMCSA and MCPs?
Yes. We have a brand new safety girl. She's got 20 years experience with some, major companies, and she has done this in the past. And so we can, help them with that. And if we get overloaded, we have a service provider as a backup.
Then the other thing is those motor carriers who now use independent contractors and want to go to this broker carrier business model, they will need broker's licenses.
Definitely.
And the recommendation I've always had is that do not have your broker's license in the same business entity as your motor carrier. Absolutely
correct.
So that you need to form another business organization, whether it be a corporation, LLC, or so forth, and then apply for your broker's license that way. And if you are brokering freight now, in other words, a motor carrier now brokering freight, and what I mean by that is this. When you broker freight, you are giving that load to another carrier, not to be confused with giving a load to your own leaser, your own owner-operator. So when you are brokering freight, you must have a broker's license as of now. So even if you don't go to the broker carrier business model and you are brokering loads, you should have a broker's license.
Back in the days when I was per se in trucking, I ran the California Cartage outfit, K&R, CMI, and West Coast agencies, all four of those. This is a typical example. There was Cal Cartage Company, there was Cal Cartage Express, Cal Cartage Logistics. This way, you didn't lose the brand name, but each individual company was its, a separate. And obviously, I can't remember now which one was the broker of it. But this is exactly what what you're talking about is having separate names for the different entities. But you
absolutely,
yeah.
Absolutely.
I don't know if there's going to be any more questions. You can always email me or Miles, and we will try our darndest to get back to you. We do sell Great American Insurance to 1099 people. Each policy, Great American treats every IC, independent contractor, as a separate company. We can do a list bill to the carrier if the carrier under 376.12 wants to do a pay settlement deduction, providing they have the correct written, what's the word I'm looking for, Miles? Consent.
Lease
Yeah,
agreement.
Yeah, the consent form to make the deduction. Then we can just send them a list bill listing, how many ICs are on there and their name and whatnot, to make sure that everybody is, has the coverage. But everybody gets their own separate policy on that, and they're very strict about that. But it's obviously for California purposes. Do you have anything more, Miles?
I don't have anything. Thank you for the opportunity to provide this information. And I'm looking forward to helping anybody who wants to contact me. I know my email is not up on the slide. So my email address for all of you who are still here, it's my first and last name, MILESKAVALLER @att.net. Don't use my middle initial for the email address. All lowercase.
Jamie or Jaime, the price for the LIC processing is the whole ball of wax is $12.50, and that's per IC. Somebody just emailed about the broker model may not be used on chassis equipment. That's debatable. I don't want
I
to.
didn't what kind of equipment?
Well, there's under using the broker model, broker carrier, maybe they might be not be able to utilize the chassis equipment.
Yes, I think it's a problem because the chassis are subject to the intermodal interchange agreement, so that whoever goes and picks up the chassis has to have that agreement with the chassis company.
Yeah.
So they have to be their own carrier. I don't know that it can work.
I have a member that has an idea of that, and she's been talking with the Scopolitis group, as I call them. But I don't want to publicly say because I don't know if it's going to work yet or not. But we'll keep everybody informed. You can pick up 10-4 magazine in the October and November issues. I did an article, and I'm sure I'm going to have more articles on it on Highway Highlights that goes out, to anyone that's interested in a free newsletter from our website. But I think with that, that's should pretty much cover it. And
all right. Well, thank you very much. Have a good day, everybody.
All right. Take care. Bye-bye.